Hi, welcome to Talking Legal episode 3. I'm Praveen Gautam, your trusted marketing advisor. I help entrepreneurs and enterprises to build their digital brand and then monetize it. Today's episode, I have Len Watt, who is Building and Construction Law Solicitor. Little bit about Len. 25 years of extensive experience in liaising with QBCC, from license applications to the resolutions of million-dollar building and construction disputes. Len is a trusted building and construction law solicitor. Welcome to the show, Len. Great to have you, mate.
Yep, thank you very much, Praveen. It's great to be here again.
It's great. So in this episode, we want to talk a little bit about force majeure, especially in building and construction industry. And those people who are watching this, what is force majeure in a very layman term?
So force majeure is it's a clause or a term of a contract. It's French, meaning superior or irresistible force. So generally, it will be defined by the contract and the clause in the contract. So interestingly, not every contract has a force majeure clause,
Right.
but those that do will talk about acts of God, strikes, lockouts, etc. So to actually sort of have something be determined as being a force majeure, there's a couple of legal elements that must be that must be present. So it's either it occurs by a human or a natural event. It
Such
must
as pandemic.
Yeah, very much so. Yes. It's something that can't be reasonably foreseen by the parties. Again, the pandemic is a classic example.
Yes.
And it must be outside of the control of the parties in that they could not have prevented it from happening. So again, the COVID-19 pandemic seems to fit quite nicely into those definitions.
Right. So what you are saying is obviously COVID-19 constitute of force majeure event, yeah?
Within law, there's no absolutes, but yes, depending on the particular clauses of the contract, the current pandemic could be seen to be a qualifying cause to enact or to enforce or bring into effect a force majeure clause.
Right. So then how would you interpret the FM clause here? I mean, in terms of, you mentioned an act of God where the government's measure taken, self-isolations, travel ban, materials unavailability. So how do you interpret any clauses there?
Well, it's actually, I suppose, very, very topical. Depending on the location of the parties, the border closures that we currently have, which are an act of government or could hypothetically be seen as a lockout that would prevent somebody from traversing from one side of the state border to another, could certainly enact the clause, and there's no possible way you would think that the parties to a contract could have foreseen that, for example, the Queensland New South Wales border or the South Australia Western Australia border would be South Australia, West Australia, and the Northern Territory, West Australia borders would be closed. And with no real, I suppose, reopening date yet. So yeah, most definitely, yes. An act of government could fit the definition. Yes.
Right. So, so the definition of frustration in Australian law and how this would trigger a FM clause. Would that also mean in contractual rights and obligations of the either parties then?
So frustration is I suppose it's another part of contract law or another area of contract law which can sort of touch. But frustration. So firstly, a force majeure event relates to a segment of a contract, not so. Right. And frustration and I suppose force majeure will generally sort of delay the performance, of a particular part of the contract, whereas frustration is in relation to the overall performance of the contract. So something where the contract is radically different from what was undertaken or what was foreseen by the parties at the time that they entered into the contract. What's important to remember in contractual relationship is the court considers what's in the mind of the parties at the time when they enter into the contract.
Yes.
You can only take parties at their face value, and it's if something radically changes, then it could be a case of frustration, or depending on the circumstance, maybe force majeure.
Right. Then I'm just curious then, that's a great point. Thank you, Len. What happens when deadline has not been met? Then your contract doesn't mention anything about force majeure clause. What would happen?
Well, yeah. Each particular circumstance must be taken on its own merits. If there is no force majeure clause, then it could be that you need to enter into negotiation with the principal and or the contractor or the other party to your contract. So, you need to look at what the circumstances are, where you're at, and I suppose open up negotiations with the other party to try and come to some arrangement, because to be perfectly honest, nobody benefits from a protracted legal dispute at times like these. So it's important to be flexible, I suppose, and to keep it in mind. But that's not to say that sometimes there aren't, external factors that will have a bearing on how a particular party might react to the situation. It could be that the principal has pressing financial obligations and they must therefore press forward. As I say, each individual circumstance depends upon each individual issue depends on its circumstances. It stands on its own.
That's great. So what you're saying is anything any unforeseen circumstances such as weather delays or that's also, pandemics is definitely, as long as the terms is mentioned in force majeure, those agreements would be triggered then, yeah?
So generally, using, I suppose, construction contracts as our base, because they tend to deal with some of these issues. A lot of the time, or in fact, a vast majority of the time, it's rare that they don't. The contract will actually allow for the one of the parties, normally the builder, to be able to claim extensions of time in relation to rain delays or in relation to items that are outside of his control, which will delay the date of practical completion. That's a normal part of construction contract administration. You need to be on top of, as a builder, you need to be on top of what's happening on your site in relation to rain delays or in relation to, for example, having variation approvals signed off, which can be a delay. Sometimes there are other factors that are already contained within the contract. The force majeure is almost a step again. So we're looking at I suppose another level of issue, and the force majeure is not necessarily shutting down the contract. It's allowing for there to be almost a cessation of what's happening for the period that you're claiming in relation to that particular matter. Hypothetically, we can't, you can't take, some component of a construction project into Western Australia from South Australia until the border reopens. There's no point the parties going to court over it, because it's a simple fact that the border's closed. The inclusion of a force majeure clause into the contract would certainly fit the elements, of a force majeure, and would then allow for that particular part of the project to be extended until you could then, get across the border, get the material to where it needs to be.
That's a great point. So just curious on that then, if, first question is, if the clause is not mentioned, let's say, doesn't mention coexist in the subcontractors or supply arrangements, what would happen if these kinds of clauses are not mentioned? That's a question one. But the two is also, if, as you just said, can we able to extend that contract deadline? What's your thought on that, Len?
So, if your contract, look, one of the anybody from the building industry who's listening to our discussion today will have heard the term on budget, on time. It is almost like a mantra. You finish the work within the budget and at the time you're supposed to. It's always a relevant factor to a contract that there is a time restraint. Within the property market, when people seek an extension on their their conveyance, the solicitors, when we're exchanging emails, will more often than not, on the bottom of our email, we will say that time remains of the essence. That is, time is important to the contract. It always is.
Yeah, that's so pretty much someone have to meet that deadline. No matter what, as per the contract. That's
subject to an agreed variation to the contract, where the parties go. They come to an agreement that there needs to be an extension of time. And the builder or the contractor will put forward to the principal, I'm seeking an extension of 2 weeks because I'm not able to, be able to undertake A, B, C because you haven't done X, Y, Z, and I'm seeking an extension of 2 weeks because of that. Your practical completion will be delayed. We want to have 2 more weeks to finish the work. Now, the interesting thing with this, and we probably move a little bit away from force majeure, but still it's relevant, is that the idea then is that the principle of the contract, because they may have caused the delay, give an extension to the contract. Otherwise, what happens is that the term time becomes at large in relation to completing the contract. If the principal interferes with the course of the works to the extent that the contractor can't complete them in the given time because of the actions of the principal, then you can't hold the contractor responsible for the time.
Understand. Now that's I get that. Again, almost going to the basic, isn't it? Pretty much the contract should have the strong and all the clauses here, pretty much.
It's important that I suppose all the parties understand what their rights and obligations are under the contract. I sort of would hate to guess at how many contracts out there right now require a review and some administration in relation to the clauses that they contain that are not happening, because in the hurly-burly of what's going on, picking up the contract and reviewing it is not the most important thing that the guys have to do. But in a month or two's time, when it comes time to sort of start to come out of all this, then it becomes extremely important. So, there's certainly right now, I think, a need or potentially very much a requirement for some of these things to be addressed. And the relevant discussions opened up and matters put to bed before they become more serious.
I get that, Len. I totally get that. And as a trusted legal advisor, your focus is, the solution to a particular problem is necessary rather than just a legal solution.
Look, I have been lucky in my broad education, I suppose, to work with and for people who have been commercially minded, and to me, I think we've discussed before, I see my job as preventing someone from having a problem not marching in after the problem's happened. My job's to, if I can, stop the problem from happening, or at least mitigate the risks.
That's it. So being a more provocative, isn't it? Now, that's a great point. And I think that's what makes you guys a difference in the marketplace. Obviously, there's so many legal firms, but they just focus on the legal solutions. But the whole idea is to give that holistic solutions to the clientele, and having that commercial experience that makes it a whole, the point of difference.
Look, I personally, yes, I think so. I mean, I think that, and a lot of most of my team have worked in other industries or have building industry experience before they've come to work for us. So we tend to take a more commercially minded position. I think a lot of times. I mean, you have to back up that with sound legal knowledge and ability, which is certainly there. But why go to court if we can't negotiate our way out of something? It seems to me to be the more sensible way to go. And the force majeure, the inclusion or not of a force majeure contract clause in a contract right now is a very sort of relevant, I suppose, issue. To my mind, if I'm acting for the principal, I'm sort of subject to his or her constraints. I'm potentially thinking, look, we may not have a force majeure clause here, but shouldn't we potentially consider whether or not we approach the other party and make sure that that we sort of alleviate any problems that might be coming? Because my client's going to want to know what obstacles they may have in front of them, as to deadlines and timeframes, etc. And I think that for their builder or contractor, it certainly would allow them then to concentrate on the other parts of what they need to do, finishing the job, as opposed to worrying about whether or not they're going to have some sort of legal issue with the other side to their contract.
Such a deep topic, definitely. And I'm conscious with the time. We're just running out of the time, and some of the viewers, I see that great feedback here. We're just on the live stream on the Facebook. If that's anything, if you have any questions for Len to ask, just write down the comments or share this post, or if there's anything he can be of value, definitely. Now, anything you want to add before? Obviously, this can go more deeper, and I think we may need to do a second part as well next week on the fourth episode of Talking Legal. Anything you want to add today, Len, before we wrap up for today?
I don't think I can stress too highly the importance of reviewing the terms and conditions of your contract. You need to, or I think that there's a need right now to engage with your legal advisor, and there's a need to actually review the contract and just get ahead of the issues that may or may not be there. We're deep into this crisis now, but hopefully we're on the way out. To my mind, I think that there are potentially more issues coming out, and once we get out, than what there are right now. I would suggest to anybody who might be watching to just get ahead of it and start talking to their legal representatives now.
Absolutely, and this applies both on commercial as well as residential, I would imagine.
Yes, most certainly it does. Yes.
Yeah. Now, so if people have to get in touch, I understand you have got a book online as well on your website. So what is the easiest way for any viewers, if they're just watching this video from different social media? What's what would they do?
Okay, so obviously, if they go to www.beckerwatt.com.au, there's a form there that they can use to come through to us. We also have a 1300 @legal telephone number, and that can be used anywhere in Australia, and that will come through to us, and we'll certainly then take the relevant details and get back to them and then start to work with the people to solve their issues. So either via the easiest ways are by telephone, obviously, traditionally, or via the website.
Book online. And you have an initial consultation as well, some block of time, isn't it? 20, 30 minutes or so?
Yeah. That's yes. And that can be booked, and we can schedule that with one of our experienced lawyers, and they can go through and that's almost like that's I suppose a collection of information. So talking about it, figuring out what's going on, asking for documents, and then we move forward from there.
That's great. Thank you so much for your time, Len. It's great to have you again. This episode we talk about force majeure in building and construction industry. If you have any issues, or if you would like to know more about the contracts in building construction, whether that may be residential or commercial, please feel free to contact Becker Watt. Thanks, Len.
Thank you very much.
Next one.
Thank you. Bye-bye.
Bye for now.
Bye.
Yes.